So I was given some very specific questions. That review, unfortunately, I apologize, went a little longer than I anticipated, but very specific questions. So I'm gonna go through those questions with some answers that I hope, if nothing else, gives you something to think about as you enjoy lunch. And hopefully beyond that. Do I need a power of attorney document? Again, it's about you, right? This is about you. At a time when you're not physically and/or mentally capable, depending on which document you have. Again, if you're touring, I strongly suggest you do a general. If you're going to the hospital, I strongly suggest that you would want to have a general. So a general power of attorney, again, very specific on your time period, up to you. Just remember, it's when you're physically not able, generally speaking. A power of attorney for personal care, as I explained to you already. If you're happy with the healthcare taking care of you, the healthcare system, fine. You know that they're going to take care of you from a health perspective. It may not be your wishes, by the way, because the healthcare system has to follow the rules, professional rules, so that you may not wish, for example, to be hooked up to machinery that keeps you alive. Gosh forbid something would happen and that would be the predicament you're in. But it may not be your wish. Well, they're going to hook you up and they're going to do their best to keep you going. And they're going to exhaust all potential avenues before. And that may not be your wish. But if you don't have a power of attorney document with some clarity given, potentially that's what can happen. Your personal care, again, I mentioned those already. So health is covered, shelter is covered by the healthcare system as well. Okay, the other four categories are not. And the continuing, well, the problem with that is if you don't appoint somebody, and you should be doing it at 18, believe it or not, any age beyond 18, because you never know what's going to happen 5 minutes from now. And it's always good to have these documents. Where do you put them, by the way? Where should these documents be? In your possession. No one should have your will. No one should have your power of attorney documents other than you, in your control. Sometimes people will leave them with lawyers. Problems with the lawyers is twofold. Most lawyers that will keep people's documents are probably the age group that you are. And they too retire. They're required by law when they retire to appoint another lawyer to look after their records for 7 years. Often, though, I found is that when somebody goes, they knew that John was the lawyer. He was always, my parents always went to John. He was 40 years down the street. They go knocking on the door, John's not there anymore. There's no sign saying who the new lawyer is. Go to this lawyer. So then it becomes a problem of trying to find that will or that power of attorney document. Remember, they're only required to keep them for 7 years. The way the rules are with respect to keeping documents for privacy purposes, a lot of lawyers today are not doing it because it's extremely expensive. In fact, you'll find places like Toronto, they will actually charge you annual fee to keep your documents on record. So where's the best place? Not a safety box. No, not one. Yeah.
Learn something else.
Yeah. Because what happens when you go to the bank, the financial institution, to access the safety deposit box? They check to see if you're entitled to have access. So, yeah, gosh forbid something happened to you. Your will is inside that safety deposit box. Okay, that's cool. We know you got a will. That was smart. Person comes up, shows the death certificate to the financial institution, says, I need to get in the safety deposit box because the will's in there and I've been appointed executor. And they go, that's wonderful. I'm sorry to hear about the loss. And you go, but I need access. They go, I'm sorry to hear about the loss. And now you got a problem because you have no legal authority to get in the box. So you end up going to court, or could. And guess what that triggers? Probate, which of course triggers the estate administration tax. So very, very problematic in that action.
This is the power of attorney?
Power of attorney and your last will and testament.
Yeah, okay.
If the person does not have access or is not on your documentation giving access to your safety deposit box, they're not getting in. That's the whole point behind them, right? So what I always suggest to people is keep it in your own possession.
In the freezer.
I'd say your favorite book. Yeah. But what I say to you, just a quick little trick, I should have done it. Get an envelope, draw on the envelope. Put your signature, put whatever you want. Something that works. Put a smiley face, whatever. You don't have to be an artist. Put your document inside that, and then you get your favorite masking tape. And literally masking tape the entire envelope. All the corners, all the flaps. And why do you do that? Because you've sealed your document inside there. If anybody were to open that envelope, they can't use Steam. It's not going to work. And you can look at that envelope and know very well nobody's actually seen the document, because there's your drawing, there's your whatever you put on there to identify it.
Yeah.
So it's safe. You know that it's safe. Now people say, well, somebody comes in and steals it. If they're coming in your house to steal your will, you've probably got a bigger problem. Yeah. I would suggest that you have a much bigger problem, actually. Yes?
I missed the part where you said where to actually put that.
I can't tell you where. I can tell you where not to, like I say, is be very careful for lawyers nowadays, because of
Yes,
you could be charged, for one. Second is they may be retiring. The safety deposit box is not a good spot. So what I'm saying is keep the copies in your own environment. One way to do that is put them inside an envelope. Do something to the envelope that makes it you, and then put lots of tape around it so it can't be steamed. And like you could leave that on the coffee table, and every time you look at it, you know that it's not being touched. If you're going to have these documents, I've heard, well, what if there's a fire? All right, provide a copy to the family member, and when you go for dinner, can I see my will? They're going to show you the envelope. You're going to know at a glance that everything's cool. They haven't seen it, right? Because are they entitled to know what's in there? No. Should you be telling them? I'll suggest you're not. Because what if you decide tomorrow that you want to go on a trip around the world and you want to have fun? That's your money. That's not their money. That's your money. So go have fun. Go have it. Enjoy it.
Where's the original one?
You do the same thing with the original. So what you can do on the envelope is just write the person's name. Now, if it's your will and your executor is William, don't write Will. Okay, write William. But other than that, put their name on it. Tell them it's in the event that something happens related to your power of attorney or the need for your will. You'll find it in One Flew Over the Cuckoo's Nest, which is sitting in my library next to whatever. All right. So, the world of conflicts. I see conflicts all the time. The biggest conflict comes from the lack of clarity. Folks, if there is somebody in your family that you do not wish to receive something when you have packed your bags and moved on, that's my polite way of saying after you've passed, do not put them in your will. The moment you write them in there, you might go, I'll fix them. Make my life difficult. To Johnny, I give $1. Take that. Worst thing you can ever do, because Johnny now has entitlement to your state. You've just opened up the door for a challenge. Okay? Tell Johnny why you're alive that you're not happy with him. That's fine. But don't put him in there as a way of trying to say that you're not happy with him. Avoid that. That's one big conflict that comes out of that.
Really?
Oh, yeah. So you put them in there.
If somebody said in the will to my son,
I leave nothing.
I took care of him before I died.
Yeah. Nope.
Really?
Because now he's your son. So the Succession Reform Act gives him entitlement. He's written in your will. He's not got a challenge. Because you can't challenge a will unless you actually have an entitlement. You just gave him an entitlement.
If you say, I do not wish the following person,
Don't put them in.
so don't put anyone in.
Do not put them
Even
in.
though you say do not.
Do not put them in. Put in the people that you wish. And they'll get the point. The message will be clear by the fact that you did not include them. But if you put their name in there, you are opening them up to be able to challenge. Because of the very fact that their name is listed, they have an interest in the will, they can challenge the will. That is then what? That nasty word that you brought up earlier? Probate, which also triggers eats.
I have a question. When we made our wills many years ago, we just put in our grandchildren. Didn't name them, just said grandchildren, because we knew there was more coming on.
So were there children present at the time you wrote that?
There was grandchildren.
Yeah, did you identify at least those ones?
No.
Okay, did you specify whose children they're going to be?
No, we just said it.
So they can be an adopted child, grandchild, they can be a natural grandchild,
What about?
they could be the third family, third time in marriage.
Yeah, I guess.
You see where I'm going with this?
I see where you're going.
You're almost bringing the zoo in.
And then if they're,
There is a way to write that appropriately. What you do is you identify the children that are born, and you add the fact that in that relationship, if they're an additional child, then the distribution includes that child or children. But there's a proper way to write that, but you have to be careful because, for example, that grandchild, whomever that child of yours is, happens to divorce and then they go off and have more children. Are you including them or excluding them?
as a second.
That could be a long
parents
list.
might come along with
Yes,
some,
yes. And that partner of the grandchild, and yeah.
okay.
Yeah, you want to be very, very specific. So watch your wording. A lot of times people appoint more than one person to represent them. I always recommend that. I think it's a great idea, okay? And they will often put in the word "and," so Bob and Mary as my attorney or my executor, which is great because it requires, the "and" requires them to work together. So every decision they make is they must agree on the decision. One of the reasons why you don't want to do 3 people, because we're not going to vote on the best approach here. You take the 2, you appoint them. The word "and," do not use the word "severally" behind it, which if you print out these documents, so often they will say jointly or severally.
Yes.
Yeah, the severally means independent. So why take 2? Why would you have 2? You just told them they can work on their own. And again, the opportunity to abuse you is there because they can work independent. The other person won't know that what they're doing necessarily. The problem is that people don't realize is that they're still both accountable for the actions. So the other person can be held accountable for the actions. So Bob can be responsible for Mary's actions. Even though,
So there could be theft.
yes, Mary could be ripping you off. Bob's still legally
And
responsible
Bob's
for
gonna
that.
be responsible.
Yep, he's
So
going to be
they-
held
They
responsible.
could both be charged for theft.
They could. And Bob goes, well, like I didn't engage in it. Yes, but it's called willful blindness in court.
Should've
And
known.
you should have known. And your responsibility, because they appointed you, was to protect the individual. You failed to do so, you're accountable. So you got to think, oh, I don't know what this is. Ignore that part. But 2 down, that's supposed to be TWO. My apologies. Always think 2 down. So yes, you're in a relationship right now. So in your relationship, you've appointed your spouse, which is great. But what happens if something happens to your spouse? Now you're in trouble unless you've done your documents such that in the event that my spouse predeceases me, not capable, whatever, or wishes not to be engaged, I appoint this individual. Always think 2 down. Same thing as in a way of for your power of attorney document, but more so too in your will. You want to leave something to a grandchild. Well, what happens if that grandchild were to predecease you? Gosh forbid that ever happens, but it happens, folks. So what happens to that part that you were decreeing for that child? What happens to that? Does it go to the parent? Does it go to the other children? Does it go back into the estate? Always think 2 down. This is where the problems come in. Watch your trigger mechanism. That wording is so important. And here's your choices. Who are you going to pick? Oh, he's such a button. He's a button, He made my life since the day he was born. And go, yeah, that's awesome, but he also might be the one that's ripping you off. You know, because by the way, it's 24% chance it's your son and 23% chance it's your daughter, and then the rest of the 50% is other loved ones. So just be careful you do that. Watch your promises too. I so often hear, you know, when I pass, you're going to get $100,000. It's in my will. Really? So you're worth $100,000 to me, are you? Don't tell them. Go enjoy your $100,000. If there's something left when you pass, cool. But don't tell them. They're not entitled to know. Nor should they know. If you're giving them an appointment in the sense that you want them to be your executor or your attorney, that's good. Have that discussion with them beforehand. But don't sit there and say you're going to get X number of dollars. Now, differently, you have a painting, your favorite painting, or something you're collecting that you have a family member that obviously will treat it as well as, and that's who you want it to go to. Telling them that is absolutely fine. But don't put a value in there saying, when I go, you're getting $100,000. Because you don't know what's going to happen. You put them in there, but don't tell them. That's my personal. There's your biggest one. That's today's families. And I'm really, really afraid that the way things are going right now, the economy and everything, we're going to see more of this. I call it the implosion of the family. It's absolutely amazing how these tight-knit families, you throw a will, or, a power of attorney document in the middle of them, and there goes the family entity, right out the door. Yeah, so if you're not careful in your wording, if you're not careful about who you pick, that could be your legacy. And no one ever wants to be associated with an implosion of your family. But unfortunately, it happens all the time. Changing your will was a constant question. Remember, or your power of attorney documents, once it is witnessed, you cannot change it. Don't go in and make pen ink amendments. You could very well invalidate, you will at least validate the paragraph or the line that you've changed, which could be very, very important. But you could invalidate the whole document by simply going in and trying to do an ink amendment. Why is that? Because remember, the witnesses sat before you, the document that you signed was what they observed, you were aware of that, they didn't have to be available, they're attesting to it, they're not attesting to that change. If you have to make a change, rewrite the document. And if it means a simple thing that you take the document that was produced and you're changing a name, so be it. Type it back out again, put the new name in, sign it before two witnesses.
What about a codicil at the end, you know?
Codicils are attachments, and the problem with a codicil, again, opens up the potential of challenges. So if you can avoid a codicil, always better too. You know, if you're changing the executive, for example, we would do the document. Just redo it. So much easier. Remember that when you author a new power of attorney or a last will and testament, it invalidates all previous, okay, upon that signature. That's why it's so very important to be careful when you sign a bank one. Also, if you're producing a document, let's say you've got land in Florida, you produced a last will and testament for that land in Florida, make sure your Ontario will says, my land in Florida is covered under a separate state of Florida will. Otherwise, when you sign that one in Florida, you technically invalidate your Ontario one. Does that make sense? Okay. Revoking, you can revoke at any potential. You can revoke it. You have them in place right now. It's just I, Jane Smith, on this day in the province of Ontario, revoke my power of attorney for personal care. Now, it's automatic, like I said, in the production of a new document, but there are situations to do what I call stop the bleeding. So you're potentially the victim of financial abuse through the use of your power of attorney document. You can revoke as long as you have an understanding that you're now responsible for your property.
I read that you had to definitely have a witness.
Sorry?
Definitely have a witness.
Yeah. It's always better to have a witness, definitely. Anytime you do anything like that, legal documents should always have
And
witnesses.
you could just throw it away, you got to.
No, you keep it.
Keep that.
Yes, you keep that. And you make sure that that's distributed to anybody that may have seen the power of attorney document or acting, i.e. a financial institution. So let's say that your continuing power of attorney, somebody's acting on it, You have capacity to revoke, which again, you need to know that you are now responsible for the management of your own property. You take that revocation document to the bank, and that now stops what I call the bleeding. So from there forward, the bank should not be giving that individual any access to your financial. It's not going to solve the problem that you're having. It's going to stop potential problems moving forward. Does that make sense? It's a bit of a stopgap. Okay, rights of siblings and relatives. They have no right, folks. They don't. You do. This is about you. It is, you raised your children. They are what they are. They're adults now. They're out there. They're doing their own little thing. They've got their own life on top of yours. That's great. If you want to leave them a legacy, okay, I got that. I understand that. But that's not a right. It's not an entitlement. It's your wish. And if you change your mind, so be it. You're allowed to change your mind. It is all about you. And so often I see it. Like I remember with my parents, one day telling me a story. They went for a drive. They got back really late. They were extremely tired that day. That's why I got in the conversation with them. Why are you so tired? I said, so why didn't you stop for a hotel? Oh, it costs money. So you know what I did? I looked at him and says, if you die with money in the bank, I'm going to kill you. And I got the weirdest look. But the point was, go have fun. It's yours. I don't want it. I'm not entitled to it. Go have fun. Don't deny yourself at this great time of your life. It's yours. You don't owe me nothing.
Amen to that.
Yeah. And I'm serious, folks. So often I see that with older adults. They sit there and say, wow, I got to leave something for my children. You raised a child. Congratulations, they're doing great. If they need you to survive, that's their problem. They're doing something wrong. It's not your problem. So if you wish to help them out when you've packed your bags and moved on, that's your choice. But it's not a right. There's no automatic entitlement. They don't have the right to be your executor. They do not have the right to be your attorney. I've seen spouses not appoint the other member to be their attorney. Why? Well, because that was their wish. What was their reasoning? Who cares? That's their wish. That's their entitlement. There's a variety of reasons why they might have done it. Parents that don't leave everything to all their children, so what? They didn't get that money that they thought they were going to get, or that cottage that they thought they were going to get. Go out and earn it. Key consideration is the right. You can put anybody in you want, okay? It doesn't have to be. And there's absolutely no guarantee that you're not going to cause problems in the family. It happens all the time. I see families, it's scary what happens in the way of the world of families. And I suggest you it's going to get worse as the financial world gets tighter and tighter, because there's the society today, the belief is that I want it today, I get it today, and then I'll figure out how to pay for it. You're generally not of a generation where that was true. If you spent $2, you had at least $3 in the bank, and you didn't like to borrow money, mortgage you had to, but other than that, forget it. That's not today's generation. And if you're not aware, like today, the interest rate's about to go up the 6th time in this month. Gas is projected tomorrow to be $1.72, by $2 by Christmas. There's a lot of economic pressure. You're not their ATM. You're not an automatic teller machine. If you're not sure what an ATM is, you're not their bank account. You're you. Guardianship, the world of guardianship is very, very important. It happens often. Under the power of attorney document, you're technically a guardian if the requirements are met. But guardianship itself means it's from a court ordered. It's that higher level beyond your power of attorney document. It It can be appointed through the public guardian trustee, which is the government agency that will kick in, potentially, or it can be someone else that the court
And
appoints.
it's above the power of attorney?
Yes.
I thought the power,
No.
you could.
No, your guardianship, your court order is higher than the power of attorney document. Yeah, it trumps everything.
So where does that come in?
For example, you're being financially abused by your attorney. Okay, so the only way to trump that document that gave them authority to access your finances is for the court to issue guardianship. And we may use the Office of Public Guardian to do it, or a family member could be go to court and say, I need to take guardianship to protect her from the attorney. That's the trump card. Okay, the courts don't like to do it, but it happens. I do a lot of referrals to the public guardian and trustee.
And who can apply?
Sorry?
And who can apply for that?
Anybody. It'll be up to the court to decide whether you're appropriate.
That's kind of scary anyway.
Well, no, trust me, it's a very stringent process. It won't be the mailman, okay? It might be the person who happened to be a mailman in his profession, but it won't be your mailman, okay? The courts are very, very stringent, and they do not treat this lightly. It's very challenging, very difficult to get property, guardianship of property, even more so personal care, because that's your civil liberties. All right. This is the other one I hear about all the time. Mom wanted me to have the $100,000 while she's not being paid. She wanted me, she gifted it to me. Well, folks, you can gift anything. You are allowed to gift whatever you want. You can take the shirt off your back right now and pass it to another person as I hear, have it, as long as you're a capable mind. So as long as you understand that when you step outside, you might be embarrassed for throat because you don't have a shirt on anymore, but you might get wet, you might get cold. As long as you appreciate that, you can gift anything. But if your capacity is proven to no longer be, gifting stops. And I see that all the time. And they go, oh, well, Mom wanted to. Yeah, well, Mom's in long-term care because her capacity isn't up to par. You can't be taking that $1,000 a month. And you can't tell me she wanted to because she doesn't even appreciate the problems. So gifting is used. I don't know where 101 rip off grandma. I don't know how people know to use that verbiage all the time, but it's a very, very dangerous issue. And then most important of all, I want you to always remember, and I can't overstress this, it's your money. It's you. It's everything about you. It's not your spouse. It's not your children. It's not your next door neighbor. It's all about you, your wishes, and ultimately your well-being. So the onus is upon you to make your documents stronger, avoid those standard printout ones, put a narrative in that works for you, put clarity in for you and for the person you're asking to do it for you, so that they also have the ability to express what you want with certainty. And with that said, the last thing is, when's it a crime? The moment they take money that doesn't belong to them, the moment they get entitled to your residence, then they shouldn't be, potentially that's a crime. It may be a civil issue, or it may be a criminal issue, or it could very well be both. What you want to do is make it tougher so they don't even think twice about ever being able to do that. You take away the carrot. There's your biggest ones right there. Your joint bank account, that's the biggest problem I see, followed by joint ownership. I've seen it all the time. People change title to their residence, and all of a sudden there's a mortgage on there, and they go, I'm mortgage free. No, you're not. I've actually seen it where the elder person was actually paying the mortgage every month as well and didn't even know they were paying it. So, and they didn't get the money. So with that, I talk longer than I'm supposed to.
One question, you definitely should have a different person for the power of attorney for health and power of attorney for personal care. You shouldn't have the same person.
I would suggest to you that what you do, I would never suggest that your attorney and your executor be the same person.
No.
Because that's a check and balance that you build in, okay?
But
So that's your first one. No, that's your first one.
Okay.
The second one is, I will never suggest to you to have one person appointed.
For
your attorneys or your executors. Always appoint 2. Okay? Why? First and foremost, most people, if they know somebody could be looking in over their shoulders, less temptation. It helps to keep them on the straight and narrow. So it's a built-in check and balance. The other part is you have to realize that what you're doing is you're asking individuals to live their life with all the things that go on in their life from a day-to-day exit, and that list is long, especially if you've got little ones, you know better than I would, right? School, sports, yada yada, work, balance, but you also want them, you're expecting them to do the same for you. Doctor's appointment, dental appointments, get you between point A, point B, making sure you're fed, maybe making meals for you, coming to do the clothing, the washing for you, et cetera, et cetera. A lot of stress on one individual. It can be draining, and what you get is caregiver burnout. And what can happen there is the caregiver does the best they can to get by. Doesn't mean you're getting the care that you should be getting because they just don't have anything left in them. They're burnt out. So if you get 2 people, you help to share the responsibilities with them.
For both, if 2 people different, like,
Well, which again, as long as you get those 2, you get that check and balance. So for personal care, if you can do it, have 2 different people or 2 different groups, if you would, appointed for personal care and property, always recommend that. Often not reasonable. So what I would say is 2 people appointed for personal care, same 2 people maybe for the continuing power of attorney for property, fine. Always the check and balance, because those are 2, carrying of the stress, carrying of the weight, sharing of, but don't make those 2 people your executor. Because they always realize, they're on the back of their mind, somebody's going to see the books when grandma's no longer, or mom, or whatever the case may be, is no longer with us. There's a chance they're going to figure it out. We got to keep on the narrow up and keep things straight.
Thank you, Martin, very much.
I warned you, these conversations can go very